Good morning, everyone. Thank you so much for joining our Focus online workshop today. Today we have our special guests, Kim and Wayne. Let me introduce you to Kim.
Am I on? Okay. Hi, I'm Kim Martin. I'm an attorney at the law firm Nadler Biernath. I started out my life as an attorney in 1999 as a tax lawyer, and then kind of reinvented my practice after I had a child with autism, and I decided to focus my practice entirely on special needs planning. So that's what I do now, and in fact, that's what my whole firm does. We all specialize in some aspects of special needs planning. I'm not going to give you all my credentials and everything because there's a handout that goes with this talk today, and I believe Jade is going to tell you how you can get that. But it's sort of an article that can accompany this talk, which is about divorce with a special needs child. And at the end of that article is a lengthy bio. So if you want to read all of my credentials, you can read them there. I think honestly for this audience, the best credential I have is that I am Finn's mom. Lots of you know him. He's 14 now. And we've been doing focus events and camps and everything since he was about 4. So I'm a fellow special needs mom, and if you want to find out more about my professional credentials, you can just take a look at the bio at the end of that handout.
Thank you, Kim. Wayne?
Okay, so good morning. My name is Wayne Morrison, and I am a family law attorney. I've been practicing law for 24 years, specializing in divorce or family law for the last 21 years. And my practice is at Kessler and Salmiani. The firm does exclusively family law work. Family law encompasses everything from divorce to prenuptial agreements, divorce, postnuptial agreements, custody, modification. I've had a fair amount of experience in representing parents with special needs, and I look forward to sharing some of my experiences and giving you all a little bit of additional information that if you ever need it will hopefully prove helpful. So, Jade, at this point, I guess we'll start with the PowerPoint.
Yes, absolutely. And everyone who signed up through Focus for this workshop today received an email today with the handout information.
Okay. So slide 1 is just basically what Kim and I did. We introduced ourselves and gave you our contact. The slide gives you our phone numbers, our emails. Feel free to reach out to us. I will not speak for Kim, but in the present environment where people are working from home, people are working from different places, at least for me, email may be the best.
Yeah, same for me.
But try both.
Yeah, email is definitely the best way to get me. My firm is everybody's working out of their houses a lot, and it's the phone is a little bit difficult.
Yeah. So the information Kim and I are going to go through is going to be more general in nature. We want you to be free at the end to ask questions. We'll stay as long as you all want, or as long as reasonable, answering your questions. But the information in this presentation today is of a general nature and does not take the place of meeting with an attorney and getting one-on-one advice and consultation.
Another little disclaimer that isn't on this slide. I believe that Focus is recording this talk, and if you're watching this later, if you're watching it after July of 2020, just be aware that some of these numbers may not be the same. So for example, the SSI numbers change every year. So the calculations would be different if you're watching this sometime in the future. So some of this information might not be exactly right in the future.
Right, and I will just build off what Kim said. You know, it's called the practice of law for a reason. It's always changing, and you know, what we give you advice on or what we comment on today may not be the same in 6 months, 1 year, 2 or 3 years. It depends on, to an extent, on what the General Assembly does as far as passing new laws, and what the courts do as far as deciding cases. So things change. The general topics for today with divorce are grounds, you know, does there have to be a fault or a ground for divorce? Child custody, child support, alimony, life insurance, and property division. And what is one of the things that our audience, that you need to think about today, and one of the many areas where divorce with special needs children is different, is with regards to life insurance. Life insurance is going to be present and exists in almost all cases, but it is particularly important for you all. And Kim's going to give you great advice on that later on, and when we talk about it, about things that you need to be aware of. So generally, people live together when they file for divorce, and there's not an issue about which county they live in or don't live in. However, if the married parties have been separate and living apart for some amount of time, they may not be in the same counties, especially in the metro area, where people sometimes, you know, you live on a border and you might be in Forsyth, your spouse might be in Fulton, and the county will depend on who is the person being sued. A divorce is a lawsuit, and it has a plaintiff, it has a defendant, and that matters. So it will be in the defendant's county. An interesting fact is that Georgia is one of 2 states that allows jury trials in a divorce case. The other state being Texas. Now, there are some issues in Georgia that a jury does not get to decide. And that is the biggest one is custody. A judge decides custody if the case goes to trial, not the jury. And then you have an issue of child support, which is kind of a hybrid where both the judge and the jury play a part in the determination of child support. But that is a topic all by itself with regard to jury trials, and we do not have time to go into that in a whole lot of detail. It's just something for people to be aware of. Child custody. All right, as I said, this is not a jury issue. The standard for custody, what a court is going to look at, is going to be the best interest of the child. And the statute, OCGA 1993, lists all the factors to be considered. And the easy way to think about it is if you can imagine and you believe it's relevant, the easy way to think about that is that the court will consider it relevant. If you actually look at the code section, and we give links that can help you do that later on, you go all the way from A through, I think it's P as in Paul, with different factors, Q actually, with different factors that a judge is going to consider in making a determination regarding custody.
So Wayne, I have a question for you.
All right.
How would specifically special needs issues be relevant? Is that something that a judge would pay a lot of attention to if you have a special needs child?
Yes. So what you take a look at is the general factors. They talk about, they even list special education concerns, but it's more than that. Um, with a special needs child, what I'm going to be interested in is the different therapies or therapists that a child might see. And are both parents involved? What are both parents doing? Is there a history of both parents being involved? How about going to the doctors, going to different things like that, involving an IEP or a 504 plan? Have the parents both participated in that? Is one parent doing really all the heavy lifting, literally, in some instances, with regard to raising a special needs child? Because what we'll discuss a little bit later on is the routine with a special needs child is so very incredibly important. And, what are we looking at is best for the child? Is it best for the child that both parents be involved? Yes. But do we want to, some normal situations that judges see in a day in, day out basis, it may be alternating weekends or alternating weeks or very inventive schedules. A common schedule is like something called a 2-2-5, and the children go back and forth a great deal. And with a special needs child, routine is often more important. And some of the things a judge normally sees may not work a whole lot, may not work well with a special needs child. And so we have to educate the judge about that. All right, so we have legal and physical custody, right? Two different issues. And that's something where parents, often get confused. But legal custody is very simple. Who makes the decisions? Who can access the records? And who gets notified in cases of emergencies? Physical custody, where does the child live? What school district? And then we have rights to relocate. And you can imagine with what you were talking about, Kim, with the right to relocate with some children with special needs, sometimes they tend to wander off, or I don't like the word escape, but maybe escape's the accurate term. And if one of the parents is going to be able to stay in the marital home and the other is going to leave or move out of state, what's the impact of that going to be on a special needs child? And again, it gives us the chance to educate the judge or the court so that they can make a good and informed decision about what's best and why it's best. What I will tell you, Kim, is what we normally see is almost always in today's world, you see joint legal custody and you see joint physical custody. And one of the things I advise my clients is, don't pay so much attention to maybe the label on the can. Look inside of the can. So you can have joint legal and joint physical custody with one parent having final decision-making authority in all areas, but it's still called joint legal and joint physical custody. Visitation is a term that is somewhat very much out of favor. We call it parenting time. It used to be called visitation. I think parenting time is a much more accurate label. Custodial periods, it could be every other weekend. And to a large extent, it can be what the parties agree. 95% of my cases, and of cases of other family law attorneys I know, 95% of them settle. And I, as a lawyer, am never going to presume that I know what is best over parents of any child, much less a special needs child. And typically a judge won't either. So if parents are able to agree on a custodial period or a parenting schedule, chances are that is going to be accepted. This slide lists the 4 common areas of what we're dealing with, which is a medical decision making, right, with regard to the doctors, therapists, educational decision making with regard to school, tutors, extracurricular activities with regard to different therapies, or activities even like soccer, swimming, different things. I doubled up on therapy there a little bit because one of the things that Kim and I have talked about in preparing for today is, and she will cringe when I say this, but horse therapy. And there is legitimate hippotherapy with regarding horse riding and an occupational therapist. And it serves a very, very legitimate purpose. And it is therapy. But then you also have therapeutic riding, which may be more of an activity. And that is an area that I can tell you is of great sensitivity. Judges tend to think that it is more of an activity and more of a nice to have and a fun to have. So if you have a child that is involved in hippotherapy, you need to be aware of it. You need to let any attorney helping you know about that. And you need to provide a lot of information, a lot of contacts. You need to start giving us all the tools that we need so that we can prove that this is not a nice to have, but really a need to have.
So Wayne, it sounds like you're saying it's helpful too to educate your attorney about things that, it's important as the client to make that distinction for your attorney so that your attorney can make that on your behalf later to a judge.
Most definitely. I have had more than one special needs parent tell me that if you know 1, 2, or 3 special needs children, then you know 1 or 2 or 3 situations. And that every situation is different, and every child is different. And so you are not going to be able to give us, well, I'll take that back. You can't give us too much information. All right. And I have had clients inundate me with written materials. What I will tell you is tell us what is needed, why it is needed, and help give us the supporting information for why it's needed to educate us so that we can educate some of the other people that are going to be involved in your case. One of the things that we ask for is I want to know the therapists, right, that are involved. So if you have hippotherapy, I'm going to want to know the name of the occupational therapist. and I'm likely going to want to speak with the occupational therapist rather than just someone who calls himself a therapist and is trained on dealing with children and horses, which is valuable and can be very helpful, but might fall more in the nice to have rather than the need to have category. So religious is last, and I've had several clients express frustration about religious decision making being last. What I will tell you is if the parents agree, then there can be an agreement, but typically other than that, what normally happens with religion decision making is each parent can take their child to religious services of their choice during their parenting time, or not to religious services. It's there's a great deal of freedom there, but if the child's always been raised in a particular faith, chances are the child will be able to continue to be raised in that faith. Same thing when you take a look at activities. If a child always has done an activity, has a history of having done an activity for a number of years, the presumption is, at least my presumption, is both parents thought that that activity was important and that that child likely ought to be able to consider continuing in that activity. Where you get into a little bit of a fight with activities is when activities are newly started or just started in the last year, and there's not a long history of them. So that's something to consider. All right, I'm going to call up all of this. We have on this slide, we have several witnesses that are going to help with making decisions. And the most common expert in any custody case, and particularly with a special needs child, is going to be a guardian ad litem. And a guardian ad litem is typically they're a lawyer. We've gone through some special training. We don't represent children. A guardian ad litem is the court's expert, and they are appointed by the judge. Usually it's by an agreement between the two parties or their lawyers, and they make a recommendation. Reports often are initially verbal to the lawyers to see if an agreement can be reached based off the verbal recommendations. Written reports, especially in situations if you have a lot of therapists involved and a lot of particular issues and circumstances, the written reports can be very long and very expensive. That is particularly the case if the guardian ad litem does their job properly. Some of the issues with the guardian is because they're appointed by the court and they're the court's expert, they have an elevated view, right? The court is going to give them deference. If they have done their job and they have done a good job, the court is going to give them a lot of deference. Guardians, as an expert, can testify to hearsay, what someone told them. They may have a bias. They're going to start off not having to be qualified and expert. They're going to start off being credible. So with what Kim talked about earlier, as much as educating your attorney, I want you to give me the information, and I want to talk with you about how we educate the guardian ad litem, because your case will be much, much easier if we're able to educate the guardian ad litem, and quite frankly, they agree with you. Your case is easier. It is not a good situation to be opposed to the guardian ad litem, because you have to then convince the court that the guardian ad litem is wrong, and that they're wrong. Maybe they just missed the boat, or they didn't do a good investigation. But the guardian ad litem is going to start off with the benefit of the doubt. So if you're going to trial and the guardian has a different conclusion, you're kind of starting off behind the 8 ball, and you're going to have a lot of ground to make up. So the other types of experts, and this is people that the guardian will talk to in their report and in making recommendations, are people that, if you have a guardian, the guardian gives a good report. You may never call these people as experts to testify. If, however, the guardian didn't talk to these people, the guardian ad litem reaches a different conclusion than these people, or on occasion, these experts say, the guardian misunderstood them or is just wrong, and that does happen. But you might have a psychologist or a psychiatrist working with your child. You might have any number of therapists, from feeding therapists or eating therapists, occupational therapists. You might have social workers that have helped you, educational consultants that helped you with an IEP or a 504 plan, that have helped get different concessions from the schools. There's a whole list of individuals that have, in my experience, if you have a special needs child, that you all have tapped into and have worked very closely with to get your children all the services that you can to help them. And those people are going to be incredibly important. And they're incredibly important. They ought to be to the guardian ad litem, and they ought to be for the court, because those experts, really essentially all they want is what is best for your child, and they're going to take a look at that with regards to the court. All right, so now we kind of move to money. And we have child support guidelines. So Georgia has a comparative model, and it uses both parents' income, what both parties earn. If one of the parties is not earning anything, the inclination is going to be to impute income to that party. If we're looking at with special needs parents, sometimes your earnings aren't what they could be because of all of the running you're doing to the different therapy appointments, to the different therapists, because of the child. It's really quite a handful, and at least in my experience with the cases I've seen, it falls on one parent more than the other. So we take a look at, justifying why there's maybe no income or why the income is a little bit less. We then have a number of factors we can use to talk about deviations. And Kim, that's one of the areas with special needs, right?
Yeah, and actually, something that I was going to ask you about the imputation of income is, if you do have a parent who has been the primary caregiver and the person that takes the child to therapies and activities and manages the school and everything else, does that affect the imputation of income going forward? Because those needs don't go away just because that caretaker parent now might need to earn some money. That, you know, the needs are still 100% there. So if you're imputing income to that parent, would the fact that they still have all those responsibilities affect the number?
So that is an excellent point, and I have a case right now where I am representing a teacher, and we are very much arguing, or our position is very much that teacher's income is impacted because of everything she has to do for her special needs child. She's not able to work in a public school environment easily because, you know, quite frankly, she has to pull her child out of school to take them to the therapy. Also, you know, so she's earning less right off the bat because she's in a private school. You then take a look at Summer, and her husband's position is she can get a job in the summer. Well, that's not really going to be very feasible given that she has a special needs child and what all is required of that child, of her during the summer for that child. She would actually probably lose money if she went to work during the summer because of who and what she would have to pay to help with care for the child. So the hope, from my perspective, is that we're able to educate the husband's lawyer. Failing that, you know, we try to see if we can get the mediator. Mediation is required in all family law cases in Georgia. All divorce cases. We have tried to educate the mediator and see if they fare any better or not. And at the end of the day, there are instances where opposing parties won't listen to anyone. And then the judge gets to tell them. So we will be, if we have to, we will be arguing that to the judge. And that's where you talk about feeds back in with the different experts and all the therapies that this child has, because the experts, the therapists, are adamant that it would not be good for this child to go to one therapist a day, because that would mean that after school, every day, this child is seeing a therapist 5 days a week. And that it's much better all at once, him getting out of school one day early and having all of his therapies back to back. And that's that case. Other cases, the therapist might take a different view, and they might say it's better off to spread them out. But in this case, no. And it has a real impact on the mom's earning abilities. All right. So let me ask you a question, Kim.
Okay.
In my world, 18, if I want to get child support for as long as I can, either by agreement, okay? But the court doesn't have ability to really mandate child support beyond the age of 20. If both parents recognize that the child is going to need lifelong support, and both parents are willing to agree to it, if both parents agree, I can get a court to order it, right? As long as the court will endorse or enter an agreement with post-majority support. Is that a good outcome for the family?
It depends on how you manage that post-majority support. And I think that's probably our next slide. The ages that are significant when you're dealing with a divorce and child support and those types of issues don't mean anything to SSI and Medicaid. They have their own ages that are really important. So age 18 is a super big deal when you have a special needs child for a lot of different reasons, divorce or no divorce. And one of the reasons that age 18 is so significant is if you have a child that you expect is going to qualify for SSI, which is a monthly payment, it's just a check and it's intended to be for food and shelter. The maximum SSI amount that you can get this year is $783 a month. It's kind of a strange number because it gets adjusted every year for inflation. So it always goes up some weird amount, $7, $11. So you always have sort of a strange SSI amount. But the reason that kids typically don't get SSI before they turn 18 is that until they're 18, their parents are legally obligated to take care of them, which means SSI, Social Security, looks at what the whole family has and they say, these are all resources that are available to take care of this child. And that means this child has too many resources available to qualify for SSI. At age 18, no matter what else is happening in the child's life, whether he lives with his parents, whether he's still in school, doesn't matter. At age 18, for purposes of qualifying for SSI, the child becomes a household of one. And what that means is Social Security no longer cares what mom and dad have. They only care what the child has. So as long as there's not some, well-intentioned grandparent out there who's been putting money into a bank account with the child's name on it all these years, or a trust that's not a special needs trust that benefits the child, or some other thing that would disqualify the child, as long as the child personally has less than $2,000 in non-exempt resources, they can qualify for SSI. So there's the resource test is the $2,000. It's pretty easy to just keep your child broke if you just understand that they're going to need to pass that means test, the resource test, when they turn 18. So here's the issue with child support. There's another test that can disqualify you from SSI or can reduce your SSI payments. It's the income test. So earned or unearned income offsets SSI dollar for dollar, but there are some exceptions to that when the child is sort of a younger adult. So there's a different definition of what an adult is in benefits land, and the definition is an adult child is somebody who is either over age 18 or potentially over age 22. If the child is over 18 but is engaged in some kind of program where they're either getting educated or they're doing something to teach them job skills like voc rehab, then they're still considered a child for the purposes of figuring out that income offset. So most of our kids are going to qualify to get services from the public school system until they're 22 years old. And that doesn't necessarily mean they're going to have, their senior year of high school for 5 years. They are very likely going to finish their academic curriculum, at 18 or 19 or so, and then they'll start to do voc rehab, or they might do community-based instruction, or they might go to a program that teaches them life skills. But those are all things that they're getting services that they're entitled to through the public school system. So until age 22, some of our kids are considered a child for benefits purposes. After they no longer are considered a child, they're considered an adult child. So that might be age 22, it might be sooner, just depending on what's going on in the child's life. So as long as the child is a child for benefits purposes, we disregard $20 of child support, and then we're going to also disregard a third of the child support, but the remaining child support will offset SSI dollar for dollar.
Let me ask you a question, Kim, because if a and we'll say the parent who does not have primary custody, if they're willing to pay additional support, or let's say I'm able, as a trial lawyer handling a divorce, I'm able to somehow get support beyond the age of 18, or I'm able to show that there's income and get a court to maybe suggest, using a creative statute where the child is considered a pauper, right?
Mhm.
Is there any workaround that in the state court I can engineer where the child's getting additional support beyond the age of 18 that's not going to impact SSI?
There are a number of things you can do to prevent that child support from being considered income that will offset SSI. The best thing to do, in my opinion, is to have the settlement agreement direct payments after the age of 18 into a particular type of special needs trust. So a lot of people are familiar with the estate planning special needs trust. It's called a third party trust. That trust is designed to hold third party assets, which is why it's called what it's called. But that means that trust can hold assets that belong to anybody in the world except the child. So that's where mom and dad, or maybe grandparents, might leave assets later to take care of the child after they're gone. That you can't use a third-party trust to hold child support, because the child support is a resource that's available to the child. And that's true even if it's getting paid to the parent, which it typically is. So you have to use a different type of special needs trust. It's called a first-party special needs trust. Sometimes you'll hear them called D4A trusts. D4A trusts are designed to hold assets that belong to the child. So as long as you direct payments of child support or any other type of unearned income to a D4A trust, people also use them for pensions sometimes. Like if a parent has a provision in their pension where they can name a successor beneficiary to get the pension after they're gone, they can name a D4A trust as the beneficiary of that pension for their child. And you can do the same thing with child support. So if the settlement agreement says the paying parent has to pay child support after age 18 into this D4A trust, then those payments are not considered income. So there's no offset of SSI. And the big danger, the reason that we care about this offset, is that SSI and Medicaid are linked in Georgia. So if the offset is big enough so that you lose your last dollar of SSI, you've also lost Medicaid, which means you also aren't going to qualify for any of the great waivers that are coming later in life, like the NOW waiver or the comp waiver. It's not just a matter of you're not going to get that check every month, or you're not going to get as big a check every month. If you lose your last dollar of SSI, you lose Medicaid. And the way to avoid all of that is you have the child support directed into a D4A trust at the age of 18.
So let's say that that would need to be maybe by an agreement, or and it may not be possible if, for any number of reasons, during a divorce case, people don't tend to sometimes trust one another. Divorce cases very seldom are in a perfect world type of environment. If it was a perfect, there's not a lot of trust, or at least with my cases, often there's not a lot of trust between the two parents. If I'm able to get post-majority support, which in my world, in a family law world, it's 18 unless the child's not graduated from high school, and then they have up to the age of 20, right, to graduate from high school, so up to 20 to help pay for child support, right, up until the age of 20. If I'm not able to negotiate a deal where it's paid to a first party trust. You know, we have in here a bullet point talking about a receiving parent irrevocably assigning it. Tell me about that.
So that can be done. I mean, it's not my favorite way to do it, but a lot of this work is kind of, here's my favorite outcome. This is the ideal, but here's our plan B if we can't get our ideal. And so I would say this is a plan B situation. And sometimes too, I see a lot of people who come to me for estate planning and they mention, oh, I'm divorced. And I look at the settlement agreement that sometimes is 10 or 15 years old, and it absolutely doesn't address this issue. And they don't want to relitigate, you know, they don't want to go back to the spouse that they finally finished fighting with and say, hey, we need to revise our settlement agreement, because that's going to open the door to all kinds of potentially nasty things that they don't want. So yeah, under circumstances like that, or when the divorce is in the process of happening and one parent just says, nope, I'm absolutely not going to do this, it is possible for the parent that receives the child support to just make an irrevocable assignment of that child support to a D4A trust.
Okay, so let's go through a little bit about some of the trusts. So we have the first party type of trust, and is there a place in the ideal world for both a first party trust and other trusts, third party trusts?
You know, honestly, I think just in the interest of being careful and thorough, I love it when people do an estate plan that has obviously a third party trust, because that's going to hold mom and dad's assets and maybe grandma and grandpa's assets. And the third party trust doesn't have a Medicaid payback at the end of the child's life. But the D4A trust is just this awesome safety net of a trust. And so, you know, I don't like to push people to spend money when it's not, you know, absolutely a need in front of them. But, you know, if money is no object, which is not usually the case, but if money is no object, it's a great idea to have a D4A trust for lots of different reasons. I mean, only certain people are statutorily permitted to create these trusts. And so that's a parent, a grandparent, a guardian, or a court, or the beneficiary if the beneficiary is competent, which means your child could create his own D4A trust, but he has to be not under guardianship, and he has to understand and have the capacity to create the trust, you know, with the knowledge of what he's doing. So the child may or may not be able to create this trust. So once grandma and grandpa and mom and dad are all gone, if money falls out of the sky and lands in this child's lap, there may be nobody left who can create this trust. I mean, courts don't just roam around the world going, hey, do you need a D4A trust? You know, the only time you get a court to create a trust like this is if there's been an accident and the child has gotten damages. And then as part of the settlement agreement for that accident, the court, hopefully the lawyers know enough to ask the court to order the creation of a D4A trust. But, you know, I like the idea of just having one sitting there funded with $10 in case, you know, some random thing happens and the child has money from somewhere that's more than $2,000. Because any money that you put into this trust is an exempt resource. So you can just immediately put any unexpected additional funds into this trust and continue to be qualified for all of your means tested benefits. And the two most important ones are SSI and Medicaid.
And, you know, the thing I see is the last bullet point on this slide talking about payback provisions, which means in a first party trust, if there's money left over, it typically all is going to go back to the government, right, to pay for any benefits the child might have received?
Yep, Medicaid keeps a running tally of everything that they have spent for your child throughout his life. And at the end of the child's life, Medicaid will seek what's called estate recovery. But part of the deal, part of the requirement that governs the creation of this D4A trust is that at the end of the child's life, The first beneficiary of the trust is Medicaid. So you can pay final administrative expenses and stuff, but whatever's left after that has to go to reduce the child's debt to Medicaid. And, that's not such a big deal if you're using this trust to kind of launder child support, because the money's going to go in and it's going to come out again. I mean, it's actively being used. So, if you've got $100 left in a D4A trust, then so what? Give it to Medicaid. Most people don't get too uptight about that. We're going to get to life insurance later, and that's where people really have an issue with this Medicaid payback provision.
Right.
So, I mean, the trust only has to reimburse Medicaid to the extent that there's money in the trust. So the first party trust is not where you want to stockpile money.
And that would be
it's a parking space.
A great segue for a third-party trust, right? Which is,
yeah.
It holds money. It allows other people to set up gifts for the benefit of a special needs child. It can be used as an estate plan, and it can roll money over to perhaps other children.
Later, after the child's life, other children can be successor beneficiaries.
Okay.
Yep.
And,
yeah, so that's the ideal. If we have a choice, that's the trust we want to use, because as you've said, there is no Medicaid payback. So the remaining assets in that third-party trust can go to other children or to a charity or wherever the parents want it to go.
Now, everyone, I would imagine, who's listening is somewhat familiar with ABLE accounts. I recently had a case, and it was proposed, not ABLE accounts specifically, but people, maybe both mother and father, contributing to a joint account, and that joint account then being used for the benefit of a child. And does either an ABLE account or some type of other joint account take the place of a special needs trust?
Sadly, no. This is just, I mean, ABLE accounts are still kind of new territory for everybody. They've only existed for a few years. So when they first came out, nobody really knew the answer to that question. But a couple years ago, Social Security actually created a regulation that specifically addressed this, and they have unequivocally said, if you put child support into an ABLE account, that does not mean that it's not income. So if you direct child support payments to an ABLE account or to a joint bank account or anything else, then it's still considered income to the child for SSI purposes. So it's just not going to work.
Right. So the way to deal with this is really either through a settlement agreement, getting a D4A set up initially, or later setting up for the receiving parent to assign the child support payments to a special needs trust.
Yep. And that's really your only option. It's got to go into a D4A trust if you want to eliminate that offset of SSI.
Okay. So with alimony, it's very different than child support, and in a lot of ways, it's somewhat during the 24 years plus I practiced, alimony in a typical case is not nearly as generous as it used to be. Lifetime alimony is rare. What you can have is alimony being used to maybe impact or affect property division a little bit. It could be periodic or lump sum. The recent changes in tax law really had a huge impact on my practice because the payor used to be able to deduct alimony payments, right? So it lessened their tax burden, and the recipient was taxed on alimony payments. That's no longer the case. So in a lot of respects, alimony is treated a lot like property division. Now, in my world, with child support ending at 18 or 20, the needs for a special needs child, their needs don't end at that time period.
Mm-hmm.
If I'm able to look at a number of factors for alimony and go through and talk about why a primary parent wants alimony, and that they're willing to use this alimony to help support their child, to help take care of their child later in life after child support ends. To me, that seems like a good situation in a special needs case, right? Because
I'm sorry, go ahead.
the court can award alimony and can consider the condition, earning capacity, and the abilities of the party, child care, all that, in awarding alimony. So if I'm able to get that for a child or for a parent, and not calling it child support, but calling it alimony later in life, is that a good thing?
Well, it's, getting money for your client is always a good thing.
Okay.
But this is a tricky thing to pull off because SSI, Social Security, and Medicaid they're going to ask for a copy of the settlement agreement. And the court doesn't get to tell Medicaid, oh no, this isn't child support, this is alimony. As far as Medicaid is concerned, if it's for the support of the child, it's child support, and they don't care what you call it. So for your purposes, as a way to just, get some resources directed for the care of the child, that's a great strategy, but Medicaid doesn't care if it's called alimony. If there's a provision in the settlement agreement that says, mom is going to get lifetime alimony, but mom has to use it for the care of the child, that's child support. So you really have to be careful about the wording. I mean, again, in my perfect world that I never get to have, mom would just get the alimony and there would be no discussion of what she had to use it for, and then it's alimony. But, getting the paying parent to agree to that is, probably going to be quite an accomplishment, and you may not be able to do it. So you really have to watch your language. If alimony gets paid for the purpose of supporting the child, and if there's a requirement that that's what it's used for, it's child support. So you could direct it to a D4A trust, but you can't just have it paid to mom and say, no, it's not child support, it's alimony. Look, we're calling it alimony. That's not going to fly.
All right. But if it goes to the D4, if mom gets this and she assigns it to the D4A or a special needs trust, as long as she makes that irrevocable assignment, then it's not going to, it won't impact benefits if she makes that assignment.
I have never actually seen this happen, but I don't see a reason why that wouldn't work.
And what I want to be clear about is in a trial situation, that is a very, very big ask. It is hard to get, and it would be unusual. But there have been circumstances where I've seen it. It is unusual, and it's not lifetime. I want to be clear about that. It's not going to be lifetime. And the problem with this, with asking for it, is that alimony ends if the recipient dies or remarries.
Mhm.
It's going to end. From a trial perspective or from a divorce or family law perspective, we're trying to take a look at all different ways that we can get additional benefits to help out the child. I think this is some of what we just talked a little bit about with the limitations of what Medicaid's going to take a look at with regard to how alimony is used.
Yep, it's all about what the requirements are.
Okay.
So, the more willing the parties are to just sort of hand over money and stand back and not put any limitations on the use of that money, then the likelier it is that you're okay. But parties tend not to like to do that. So that's
Okay.
the challenge. That's your problem, not mine. I just make the basket.
All right. So now we come to an issue of life insurance, which I will tell you in a divorce where there is not a special needs child is typically not a big issue. It is typically going to be term insurance. It's typically going to maybe even be through an employer, and it's not near as big of a deal. With a special needs child in a divorce, it is a much bigger deal because the need is going to be there for as long as the child lives.
Right.
And I would, we've talked about this before, you and I, and term life insurance is really not the ideal in this situation. It's much better for it to be a whole life policy, and is much better that it not even really be addressed in a court order or a settlement agreement. Is that correct?
Well, so this is, divorce lawyers hate this. They hate it. But the ideal way to do this in my world is, if you can do a permanent life insurance policy, which, yes, costs a lot more than the little bit of money for a term policy, but you've got a permanent need. You need to meet that need forever. You need permanent life insurance. So if there's a permanent life insurance policy, if the settlement agreement says you have to have this life insurance to provide for the care of the child or to support the child or whatever, it's first party. It's a resource available to the child. So when that policy pays out someday, forget all your means tested benefits. They're just gone. Unless you direct the payments to a first party special needs trust. And this is where I get pushback all the time, because people might be okay with, all right, we'll put $1,500 a month of child support into this D4A trust, and then it will come out again almost immediately because we have to pay for private school or camp or groceries or whatever. Like, fine, whatever, we have no problem with that. But talking somebody into committing, $500,000, $1 million to put it into a basket that's going to ultimately repay Medicaid with whatever's left over is a hard sell. And the way around it, if people are willing to cooperate, which is not always the case, but if you can just have the life insurance and not require anybody to do anything in particular with it, you can put it into a third-party trust, which is the ideal trust. That's our estate planning trust that doesn't have a Medicaid payback. And that's a better use of that resource. But the trouble is, you can't have any strings attached to it. So what I love to do, if I can get everybody to do it, is have one parent own a permanent life insurance policy on the other parent and just be free to do whatever they want with it. So as the owner, they can name any beneficiary they want. They can name the third party special needs trust if they want to, or they can name the pool boy. And nobody ever likes that plan. But I actually have had one set of parents who actually did that. They agreed, we're getting a divorce, but we both trust each other to take care of these kids. And they had a special needs child, and they gave each other a permanent life insurance policy. And both of their divorce lawyers were like, don't do this. This is a terrible idea. But they did it, and they created a joint third-party special needs trust. And we named that trust as the beneficiary of both of the policies. And, you know, mom and dad were both free to change that beneficiary anytime they wanted, and they just trusted each other not to do it.
So let me ask you, if the court requires that it be for the benefit of a special needs trust, does that cross the line?
Yep, it has to. If the court requires it, then it has to go into a D4A trust.
The court can't, if the parties that they'll both have a policy with a third party trust, right?
Mm-hmm.
Being the beneficiary of the life insurance policy. You know, it's a settlement agreement, and they agree, and it's going to go to this special third party trust. So you exclude the pool boy or the tennis pro. What does that do?
Well, then you've got first party money going into a third party trust.
Okay.
So now you've messed up your third party trust and you're in trouble.
All right.
You can't do it.
Okay. Well.
Sorry to be a wet blanket.
Let me ask, so that is a really good segue to this, and it's property division. And property division is one of the main elements that exists in any divorce, okay? And one of the things that if you're consulting with a divorce attorney or a family law attorney, you're going to want, if there's a prenuptial agreement, and that's at the bottom of the slide, you want your attorney to be aware of that at the very beginning. But property division is, I think, is even more important in a special needs case than a regular divorce, because I've had a number of cases where children tend to wander off, and you need to let attorneys such as myself know if that is an issue, because that might make the home and the primary caretaker being able to keep the home very much of a priority, because it is not uncommon for a primary parent to want to keep the home, and for a family law attorney to say, you know, that's not such a great idea. It is an expensive asset, and you may not really be able to afford it. You might want to look at a less expensive home. But if you have a special needs child and your child likes to wander off, and you've lived in that house for a period of time, it's likely that the neighbors know the child, that the child knows the neighbors, and it is a safe environment. There also may be vehicles that have been modified for wheelchairs, different things about that. But one of the things that we've talked about, Kim, is whole life insurance policies.
Mm-hmm.
And you know, you can use a division of property to take care of whole life insurance policies and dividing those to help provide some protection.
So Wayne, are you saying that ownership of a whole life policy could be divided up as part of a property division?
Yes.
Because
Now,
that would be my magical dream solution.
Well, because the whole life policy, unlike a term life policy, a whole life policy has the cash value. So a pre-existing whole life policy, yes. Yes. Now, what would be interesting, and I've not litigated it, but it would be something that could be part of a settlement agreement is, let's say mom gets or dad, whoever the primary, or each parent gets a certain award of assets, and they agree to use those assets to buy an insurance policy, a whole life insurance policy, on their current soon-to-be former spouse. That seems like that might be worthwhile language to negotiate also.
And that's great, as long as the language doesn't say they'll agree to buy a policy to support the child.
I understand. And what we're looking at with some of this are creative solutions, right? We talked briefly about modifications, and almost everything can be modified outside of property division. Property division is not ever modifiable, but custody changes or can change. Child support can change. Alimony can change. So a lot of this is going to be subject to change down the road. So people get somewhat upset when they go through a divorce and then they find out, wait a minute, this isn't the deal forever. It may change in 2 years or 3 years, but the short answer is yes. With regard to child support and alimony, you need to prove there's a significant change in income, financial situation of either parent. The needs of the child has changed. Any of that can be the basis for a modification. Absent a significant or material change, you can file for modifications every 2 years. You can file sooner if there is a material change. One thing that you want to understand also is in a modification, depending on how it is filed, a prevailing party may, not always, but may be able to be awarded attorney's fees. Okay? So some of what is going on is that some of these things can be changed. So one of the things we talked about early on, Kim, is that at the time of the divorce, there's not a great deal of trust typically. And as a divorce lawyer, I may be trying to simply get the best deal possible at that time, given the circumstances and the dynamic between the parties. It doesn't mean that it can't be changed later on. All right, if the financial circumstances change, if the needs of the children change, if one parent simply flakes out and all of a sudden stops contributing, stops being not financially contributing necessarily, but stops participating in parenting. That can all be a basis for a modification and a change down the road. So that brings us to this. Jade was going, if we have questions that people want to submit, I think we're a little bit over.
We are.
But if there are questions that anybody has, now's the time that we'll field them and try to take advantage of them to answer anything out there.
That's perfect. Would y'all like me to read out loud your first question?
Sure.
Perfect. Do you receive child support if your child is over the age of 18 years old?
Okay, so if child support, if we're looking at a new action, a new divorce case, and the child has not graduated from high school, and is not independent, right? So they've not married, they've not served in the army, they're not serving in the armed forces. You can receive child support, but you're typically in a typical scenario. You're looking at child support ending very quickly, and one of the things you're going to have to take a look at, depending on the circumstances, is how much money do you want to pour in to trying to get child support for a limited period of time. And if it's not going to be something that the parties are able to voluntarily reach an agreement on, you're going to have to, it will depend on meeting with a lawyer and going through very much, unfortunately, a cost-benefit analysis. And there's not a whole lot to it other than that. I think, you can be creative and look at alimony and property division to try to recoup some things. But legally, there is a basis for child support, but you're going to have to, it'll depend on whether it's worth the individual facts on whether it's worth pursuing or not.
Okay, next question. Could Kim express that in another way? That sounds scary. It looks like the child won't get full SSI until he is out of school at the age of 22.
Well, it's not a question of whether the child is still in school or whether the child is 22. It's income, including child support. So child support is considered to be unearned income that's attributable to the child, as I said before, even if it's getting paid to a parent. So that income will offset SSI dollar for dollar. So until the child is 22, often in our world, they're still a child for purposes of the definition that we're using when we talk about this income offset. So as long as they are still a child, we disregard $20 of the child support because that's a personal allowance. Then we disregard 1/3 of the child support. And then the remaining 2/3 offsets SSI dollar for dollar unless you have those payments going to a D4A trust. Once the child reaches 22, then they're considered an adult child, which also has its own special definition and benefit plans. And then we don't even disregard 1/3 of the child support. We disregard $20 and all of the rest of the child support offsets SSI dollar for dollar. So it's possible to get down to nothing. It's possible to lose SSI altogether. And then if you've lost SSI, most of the time you've lost Medicaid. So it is scary. But the way to fix it is you direct those payments to the D4A trust that we talked about at such great length here. And then that money is not considered unearned income that's attributable to the child. So the child can get their full SSI.
Great. Next question. Does that trust need to be formed prior to divorce being final? My son is 9 years old now, or later, and just worded in the agreement.
The way I like to do it, in perfect world scenario that I don't always get, is I like to have the trust drafted, signed, incorporated in the settlement agreement. So the settlement agreement doesn't just say this money will get paid to a first party special needs trust someday when the child turns 18. and then somebody has to at some point create that trust. The better way to do it, in my opinion, is to go ahead and create it now, even though your child is 9, sign it, attach it to the settlement agreement, and then the agreement is worded like, payments will be made to the blah, blah, blah special needs trust, attached here to, and incorporated by reference. And what that means is the terms of that trust are part of the settlement agreement, which tends to save people from fighting later. Because if the settlement agreement just says, go create a trust at some point to hold this money, who's the trustee going to be? Who's the successor trustee going to be? You know, there aren't that many choices with a D4A trust because it's a very heavily regulated trust. It's regulated by statute, so you don't have a whole ton of options. But the options that you do have are things that people could fight about a lot. So if you have a choice, to me, the ideal way to do this is get the trust done, get all the terms nailed down, get the actual copy of the trust attached to the settlement agreement so that it's part of the order, and then there's no more fighting. But maybe Wayne would like to weigh in on this because it's a little bit of a strategic question.
So what I will say is, yes, in a perfect world, it is best to have the trust done in advance. But if you can get an additional amount or duration on support without having the specific trust named and attached, my advice would be you get what you can, and then later on, over the next maybe 9 years, I think you said your child was 9 years old, hopefully the turmoil and the angst calms down a little bit, and there may be a better agreement that can be reached down the road with regards to the trust. But it's very much is going to, you want to get as much as you can at the time of the divorce. The perfect situation is that you have an agreement on the trust document, the trust is attached. But if you can have additional payments for a duration or amount saying that they'll go to that trust, grab them, and then fight about the trust later on, because you're getting something you might not otherwise get, and you can fight about it down the road. You get what you can.
Great. Next question. Can you get alimony directed to the D4A trust?
Do you want to take this one, Wayne? It's kind of a question for both of us.
Yes, I'll let you take the lead on it.
Well, I mean, I have never done that, but I don't see a reason why you couldn't.
So what I would do is, and I've asked judges before, and on 2 occasions have had essentially judges award alimony because in those cases it was mom was agreeing to take on additional expenses for a child or for children, and well, she was willing to do it, but she didn't necessarily have, there weren't the marital resources, or it was going to muddy the water with equitable division. I convinced the judges to award it as alimony. It was payable to mom, and mom, by her agreement, was ordered to spend it on certain things. Okay? Following that line of thinking, I would see no reason why it could not be ordered paid directly to a D4A trust. I would see no reason why it couldn't go directly to the first party trust.
Great. Next question. How is the comp waiver handled in divorce, where I am the representative employer of record? What precedent is there? My husband is trying to dodge child support since my son has a waiver.
Well, the waiver is the property of the child. and it's not typically money, it's support. So, I mean, that's something that you also have to be really careful about when you're wording a settlement agreement. I mean, there's nothing wrong with having a provision in the settlement agreement that says nobody is responsible for paying for anything that benefits will pay for. So if you have the waiver and it's paying, let's say, for your child's day program, there's, you should have a provision that says dad doesn't have to pay for the day program as long as the waiver pays for it. Because otherwise the waiver won't pay for it. I mean, if the requirement is dad has to pay for everything, the Medicaid is going to say, he doesn't need this waiver. Look, dad has to pay for it. Medicaid is a payer of last resort. So I think the way to maximize the resources that are available from all sources in this case is go ahead and say, yeah, you don't have to pay for things that the waiver pays for, but you do have to pay expenses over and above what the waiver will pay, because otherwise you've just got dad duplicating the waiver. And, I mean, dad's payment of the day program, let's say, that I just made up in my example, means that Medicaid won't pay for it. So that doesn't really get you anywhere. All it does is burn up money.
So I've seen this with some of the therapies where their therapy expenses are being covered. I really, in my mind, it's as simple as you're comparing apples and oranges. Just because you have a therapy or you have a program being paid for doesn't eliminate a parent's legal obligation to support their minor child. And child support covers part of food, it covers part of housing, it goes towards a whole host of factors. One of the things that you take a look at in therapy is, in child support, is out-of-pocket medical expenses, which are absent an agreement to the contrary. Out-of-pocket medical expenses are shared on a pro rata basis, okay? And that is out of pocket. So if we have a program that is needed for the child, or we have therapies that are needed for the child, that's great. If someone besides these parties are paying for it, it's great, and it doesn't impact child support, because those out-of-pocket expenses would be in addition to child support, and they would be shared on a pro rata basis.
But you do have to be really careful to have the wording in the settlement agreement that says nobody is responsible for paying for things that are, being provided by benefits, because otherwise the benefits are going to step back and go, sorry, you've already got this covered.
Most definitely.
So you have to word your settlement agreement carefully so that you're maximizing all the resources.
Yes, I agree with that entirely. But I don't think it goes. So one of the things with child support is when it's initially calculated, you get what is called a presumptive amount, okay? And that is simply mom's income, dad's income, who's going to be the primary custody, and it gives a presumptive amount. And we have in the materials that follow links for people to try to go and figure that out. But there are a whole host of complicating factors. Insurance, medical, there's a whole list of things, private schools. So, but I don't think that it was the legislature's intent, and I'm not aware of a parent not having to pay child support because of the government stepping in to cover programs for the child. We still, as parents, have obligations to support our children.
But remember, though, the distinction between a child and an adult child who doesn't have to be supported.
Yes.
Except by agreement.
Right, and I have seen lawyers do things there, or try to do things there with the best of intentions, to simply create problems. such as trying to have an adult child declared a pauper and the parents then have to support the child. And it's a wonderful sentiment, and it is a terrible, terrible idea.
Great. Next question is, does it matter who files for the divorce first?
Typically, no. What I tell people is, it will have an impact regarding the county. If the parents are living in separate counties, it will have an impact. If your case goes to trial, it has an impact because the plaintiff, the person who files, gets to go first at trial and gets to go last at trial. And if you are having a trial, that is a great advantage. But only maybe 5% of cases go to trial. So unlike some lawyers, I never encourage people to file for divorce so that they can be the plaintiff. If you want a divorce, if you know the marriage is broken, from a strategic perspective, filing may very well be the right answer because it'll make trial a whole lot easier. But there are some instances where I've told people, for various reasons, I've advised them to be the defendant. It is going to depend on some of the circumstances.
Great, that's all the questions for today.
Okay, so some of the resources and assistance. We have Fulton County, Cobb County, and DeKalb, and they all have wonderful programs to help individuals. They have forms online if you are wanting to do this pro se or try to do it pro se. They have help centers where they have different people that will try to help you. The courts themselves will not give you legal advice. They can't. But if you, and I caution you because I have had consults and I have had people come in with bad agreements or with bad lawyers. And quite frankly, it is less expensive to start off properly. If you start this off on the right foot, it is better. Okay? But if you want to try to do it on your own, here are some resources for the courts. And here are some other resources. You have both my firm and you have Kim's firm. The Judicial Council of Georgia, the General Assembly. General Assembly has all the code sections. The State Bar has a number of resources, and so do the courts. So I hope this has been helpful. I think I appreciate Focus for allowing me to participate and present. I'll tell you, Kim is an incredible resource as far as looking at estate plans and reviewing and looking at settlement agreements. So if you don't retain me, but you retain a different divorce attorney, I would urge you to have them run any settlement agreement by Kim, if not sooner, to talk with Kim about that, because the stakes are incredibly high and you do not want this to be done improperly. There's too much at stake.
Well, thank you, Wayne, for all the nice compliments. And I would also say at my end, having done a number of these with various lawyers, it really does matter that you have an attorney that has some experience with special needs issues, because we're just not, cookie cutter families, and we have our stuff going on that needs particular attention and particular skill. So if you can find an attorney like Wayne that does have experience with special needs, I think life will be easier and the whole process will go more smoothly.